Hi, my name is Carl Pearson. I'm an attorney defending against foreclosures, and I want to tell you about a lottery that's taking place in the foreclosure mess that surrounds us. The name of my video is Foreclosure Lottery, Original Note and Bad Faith Denial of Loan Modification Agreement. The lottery prize is the ownership of your home. And does the bank take it away from you, or can you terminate the bank's mortgage in your property? That's what the lottery is all about, and let me explain further. It's very interesting. First of all, let's talk about the importance of the original note. If you take a $5 bill out of your pocket and make a copy of it, a photocopy, and then try making a deposit of that photocopy in your savings or checking account, you know immediately that the bank will not accept that deposit. Think of the promissory note that you signed when you took out your mortgage as the similar type of instrument. The original of the note is the financial instrument to be honored by you, not one or more photocopies of that note. If you get behind in your mortgage payments and the bank takes you to court through a foreclosure action, the bank should be required to prove that it has ownership as well as possession of the original note and mortgage when it commenced the action. Otherwise, the bank's action against you could be dismissed, and you might be able to get a court order precluding the bank from chasing you any further for mortgage payments. This could enable you to live in your home without making mortgage payments. But I'm not saying that you should hold out for this result. Instead, what I'm saying is that because there are some risks of loss to the bank is more apt to give you a loan modification agreement when you are in litigation with the bank than when you are not. There have been several recent cases in which judges have not allowed a bank to proceed with its foreclosure claim because it did not have the original of the note and mortgage, or did not prove that it was the owner of the note and mortgage at the time that the bank commenced its foreclosure proceeding. In some states, a servicing agent is permitted to act on behalf of the owner if the owner has properly assigned that right to that servicing agent. So ownership or the right given by the owner. Although this is a relatively new development, it is something predictable under law. The reason is that if the bank doesn't have the original of the note, someone else may sue you later who does have the original of the note, and you could be liable to paying the note twice unless you were obligated only to pay off the original note. Now, there's another interesting lottery issue here, one that could wind up allowing you to defeat the bank's interest. And that is that a foreclosure action is an equitable action, meaning that the bank has to do equity. It can't have unclean hands in dealing with you. So the judge, if he sees, or he or she sees that the bank has committed some improper activities sufficient to say they have unclean hands, then the judge can and might well deny foreclosure to the bank because they did things that were inequitable, unjust, unclean hands. And that particularly that I'm talking about is this elusive modification agreement. The bank may well have a duty to provide a reasonable loan modification agreement to its customers when the circumstances are appropriate. Now, two things at least come to mind here, and that is that most homeowners are trying to get loan modification agreements without being in court. They're trying to get it without being sued, without having foreclosure actions. They're trying to stay out of court and just encourage the bank to give them a loan modification agreement. The banks, however, are allowing people to file those applications, but they're losing them all the time deliberately and asking them, oh, could you please submit another loan application, another loan modification application, and then you call up 3 weeks later, they say, oh, we can't find those papers, can you submit it again? Now, they're doing this 3 or 4 times per homeowner, and obviously they're doing it deliberately. They are not desirous of entering into a loan modification agreement when they're not in court. They don't have to enter into a loan modification agreement, they think. But there's a duty on their part not to act in bad faith. And if they do act in bad faith in the denial, then you have a defense which could very well eliminate the mortgage of the bank. So now let's look at what the bank does. The bank has a 2-track system here. They pretend that they're going to consider loan modification agreements, but at the same time they bring suit in the judicial foreclosure states to foreclose against the homeowner. So the homeowner, thinking that he has a shot at having a loan modification agreement, allows the foreclosure action to go in default. The bank, because they don't have any interest in granting a loan modification agreement, but they want the property to be foreclosed and sold, and they take the money. They mislead the homeowner into believing that the bank is legitimately offering the opportunity for a loan modification agreement, and that is the illegal conduct, the bad faith, the unclean hands, apt for punitive damages anywhere in the country, which can be and should be pursued against the bank as the homeowner's effort in trying to save his property. So this is very important for you to recognize. Now, another thing is that when you either sue the bank yourself trying to get them to give you a loan modification agreement, or you defend against a foreclosure action, the bank has an additional duty, even in court in many states, to attempt to give a loan modification agreement in good faith, and if they don't, they run the risk once again of being thrown out of court. So these are 2 lottery issues, as I like to call them, because the homeowner has a real shot here of going after the bank for the purpose truly of merely trying to get a reasonable loan modification agreement. That's what you want. You don't want to win a lottery, you want to get your life back in order, so that this is the way of doing it. So in New York and other judicial foreclosure states, if you sued the bank instead of waiting for the bank to sue you in a foreclosure action, you might be able to induce the bank to give you a loan modification agreement to enable the bank to avoid these issues of not having the original of the note and mortgage and having denied you in bad faith a loan modification agreement. So if you have any questions, please give me a call. My telephone number in New York is 212-307-4444. I provide free consultation, and I can represent homeowners in any courts in the U.S. through use of local counsel and pro hoc vici applications to represent you in the courts in your own state. My telephone number again is 212-307-4444. Thank you.